This video is going to cover salvage, and I put salvage in quotes, in outer space. I see a lot of this in internet forums and futurists discussing, quote, salvage rights in outer space for space debris and such. And I really thought it's a good idea to understand what the maritime concept of salvage is and how it is applicable and isn't applicable to the outer space environment. It's a major misconception that of what salvage is in the maritime concept, and an even greater misconception that, quote, salvage rights can be had in outer space. First things first, many talk about salvage in the space advocacy community, and they use that term very loosely. And when they talk about it, they talk about in the sense of grabbing a derelict satellite and possessing it, converting it to their possession, and then either melting it down or using the parts for other things. The problem is, what they're talking about isn't salvage per se, but it's what we call the law of finds in the maritime field. Basically what the law of finds says, it allows a finder to acquire title to abandoned property by reducing the property to personal possession. That's what the law of finds is, and that's what people mistake for the right of salvage. Example, Lusitania. Is a ship that went down in 1900s, and it's pretty much bottom. Nobody tried to recover it. And what happened was a gentleman came along by the name of Craig Bemis from the United States, U.S. businessman, and he went to court and basically asserted a claim, what we call an in rem claim, and basically asserted that the country of origin, Britain, expressly abandoned their ship, and there was no hope of it ever being recovered, and they granted him complete possession over the ship and its cargo versus the law of finds. So that's the idea behind the law of finds, and you'll see that unfortunately it's used a lot in interchange between what we call rights of salvage, but it's not the same thing. Now, when we talk about salvage in the maritime context, we're talking about two specific types: contract salvage and pure salvage. Contract salvage involves a contract law, and there is an actual agreement for compensation between the salvor and the owner of whether it's the boat or the cargo that they want to be salvaged, and there is a fixed specific fee for the cost of salvage. Now, there's also in these contracts a fee for the salvor even if they don't successfully salvage the cargo or the ship or the property in general. So that's very important to know. Under these contract salvage scenarios, there is a fee, but it's agreed upon, and there's also agreed upon fee for an unsuccessful salvage as well. Pure salvage, on the other hand, doesn't involve a formal agreement. It's basically a situation where we come upon a derelict vessel, and you either take it in tow or somehow salvage it or salvage the cargo on it, and without the owner's knowledge firsthand, you bring it back to the owner and say, see, I recovered your property, and now I am claiming a fee based on the law of pure salvage. So in other words, pure salvage is about the property owner owing the salvor a compensation for services rendered, or what we call in contract law quantum merit. It's not there, like I said, it's not a formal agreement, but it is because the salvor actually does perform an act for the owner of the property. Under the law of pure salvage, the owner of the property must compensate the salvor some percentage or some amount. Now that we've kind of laid the foundation between these differences here, there's one important concept to note regarding federal warships. Basically, they are not subject. Federal warships are a very special class because they are not subject to pure salvage, and they are not subject to the law of finds. Basically, when I talk federal warship, I'm talking a military vessel, a Coast Guard vessel, a merchant marine vessel, or even a civilian vessel that was owned by the government or operated under contract by civilians. that may have sunk with a cargo and such. These vessels are off limits because the federal government, whichever country of origin it comes from, continues to own the ship in perpetuity unless it expressly abandons the ship. What does expressly abandon mean? We could talk a lot about expressly abandoned. There is no specific formula for what expressly abandoned means, but it's usually a court will usually have to make a decision on whether or not a vessel has been expressly abandoned by looking at the circumstances, and in terms of a country, whether a country has actually expressly abandoned their vessels. Believe it or not, this goes back to vessels that have been lost for centuries and found. There was a recent case back in 2000 called Sea Hunt versus Unidentified Shipwrecks, where 2 or 3 galleons were found off the coast of Virginia, and Salvage went in and found gold on board the cargo. He went back to the court and filed what we call an in rem proceeding to take possession of the ships under the law of fines. Basically, the decision was appealed, and Spain came in, intervened, and the U.S. government got involved because basically they said under a certain treaty that we have with them that exercises this customary law that makes warships untouchable by these concepts of salvage and the law of fines. They said they still belong to them, and the federal court did rule in favor of the United States and Spain in this instant. As a result, the Salvage didn't get to keep all the gold, but they did get compensated for actually recovering the gold for the government of Spain. I emphasize this particular principle about warships, federal warships, because the principle is kind of floats over into outer space law, and particularly Article 8 of the Outer Space Treaty, with regard to what we call space objects. Under Article 8, ownership of objects launched into outer space, including objects landed or constructed on a celestial body and all of their component parts, is not affected by their presence in outer space or on a celestial body or by their return to Earth. In other words, if the United States launches a satellite on a rocket and it goes into orbit, and they use it for a few years, and they turn it off after a while, even though they're not using that satellite anymore, it still belongs to them. Same thing with the Apollo landing sites. All the equipment, all the gear, even the poo bags, and the trash on there are space objects that were launched into space by the United States, and they still continue to belong to the United States. Now, in this, there is no talk of express abandonment, but it's kind of implied in there that there is a right to express abandonment, but it's never been emphasized before. What you need to understand is space objects are just like federal warships. The nation that they're launched from owns them into perpetuity unless, and I'll put it as an addendum, unless they're expressly abandoned. I talked about the Apollo lunar sites, how the equipment and the lower half of the LEM and such are still the property of the United States government. Another example of this is to show you what happens when these things come back to Earth, that the same principle applies. Cosmos 954 crashed into the Canadian Northwest in 1979, made a big mess with spreading radioactive debris. Canada actually, through another convention called the Liability Convention, which we'll talk about at another time, enacted open dialogue saying, hey, your spacecraft caused some damage, you're responsible under this treaty and such. And finally, after they got the mess cleaned up and the government and the Soviet Union paid Canada, Canada had to pack up all the fragments and ship them back to the Soviet Union, because under Article 8 of the Outer Space Treaty, those fragments still belonged to the Soviet Union, and Canada, as party to the Outer Space Treaty, was obligated under international law to do so. So the issue with this is, because of that concept that's similar to federal warships in the maritime sense, the concept of pure salvage and the law of fines, which people sometimes call the right of salvage, they can't apply to this because to space objects. People can't just go and claim space objects, or go up and do a pure salvage and recover a space object and go to a government and say, here, you owe us money. Those two concepts just don't apply to outer space law. However, there is a possibility that the concept of contract salvage may actually be applicable, and with some modifications, to actually work in the outer space legal environment. We all remember Liberty Bell 7 with Gus Grissom, sank after he splashed down. And 38 years later, the Discovery Channel, along with the Salvor, went out and they located and recovered Liberty Bell 7. Now, before they did that, they had to go to NASA and get their permission to do that, because under the Outer Space Treaty, under Article 8, NASA and aka the U.S. government still owned Liberty Bell 7, and before they could recover that capsule and restore it, they had to get the permission of NASA, and that's what they did. They got NASA's permission. They recovered it, they restored it, and now it's at a museum. And I think right now it's actually out on tour for the next few years. But the idea is, in a sense, what the Discovery Channel and the Salvor did is they entered into an agreement or a contract with NASA to recover this space object. So this, in a sense, I think sets a precedent for a concept of contract salvage for space objects. The question is, even though the future of salvage in outer space lies maybe in a form of contract salvage, there are a few things that got to be done first from a legal standpoint. Under Article 6 of the Outer Space Treaty and the Commercial Space Launch Act of 1984, which has been amended as recently as 2015, the United States could grant its private citizens a license to perform contract salvage activities on space objects registered to the United States. However, right now the FAA doesn't have the authority to grant a license for an activity like contract salvage. This is a problem. Their authority, they can only go so far with their authority, and this is something Congress needs to do. They need to actually amend Title 51, Chapter 509, so the FAA has the authority to license this type of activity. What's that going to look like and when it'll happen is unclear, but it's something that's going to be lobbied, something the commercial space industry is going to have to potentially push. And at the same time, I know Representative Jim Bernstein has been very up on this type of stuff, and in fact he even recommended salvage as a future activity, although I think he was kind of didn't quite understand the intricacies of salvage. So again, this, even though the idea of right of salvage doesn't really exist in outer space law, there is the possibility that in the future, with the help of Congress and with the blessing of the FAA, we could actually get a concept of contract salvage put out there, which could inure to commercial space actually going up and salvaging government satellites for a fee, or salvaging privately owned satellites for a fee, and what they do with those satellites, whether they deorbit them or whether they as part of their compensation are allowed to keep the satellites to break down into their substitute metals or take components off. There's a lot of things that are possible with it, but right now we're kind of stuck because Congress needs to take some action to grant that additional authority. Just a disclaimer, this presentation is for informational purposes only. It is not legal advice or privileged, and it doesn't create an attorney-client relationship. I got to say that I'm a lawyer, and I've got to cover my butt. But I hope this helped clear up some of the misconceptions about salvage and its applicabilities to outer space. And I hope that you found this educational, and I'm hoping to do a few more of these presentation type series on some other topics like liability convention, some of the treaties, maybe even space property rights, which I know is a hot one. So I try and keep it short and sweet, and with that in mind, I'm going to sign off on this. And like I said, I hope you enjoyed it and hope you get something out of it.